Welcome to the 12th and the greatest international mock trial league competition yet. We began with almost 24 teams, and we are now down to the final two of the mock trial contest series. It's going to be a well-fought round, I am sure, but in order to adjudicate who will be champions, you have to meet our esteemed judging panel, and we're going to start with Miss Ellen Song.
Good day, guys. I'm Ellen, and I'm a second-year law student at UCL. I've been doing mock trial for about 5 years now, and I just want to say that you guys, please enjoy yourselves because you've already committed a lot of time and energy into this competition, and we really all appreciate that.
Next, Miss Jessica Patterson.
Hi, everyone. I've participated in several showcase rounds with Pure Potential Mock Trial in China. I also happen to work in the hospital setting as a respiratory therapist, so very excited to see the medical aspects of this case. Do your best, have fun, looking forward to a great round.
Miss Nora Sen.
Hi guys, my name is Nora Ten. I'm a first year at Barnard College, and I've done mock all 4 years of high school. Guys, just enjoy and relax. I'm super excited to see you guys perform. Yeah.
Not judging in this round actively, but observing from the side is Miss Jessie Lee, formerly of Emory, now of Columbia. Jessie, if you want to say something to the teams.
Sure. Hey everyone, I'm Jessie. I'm super excited to see what your teams have on the table. Yeah, have fun.
Jessie is a multi-time national trial champion from China. But finally, our presiding judge, voted by the folks who attended the tournament as one of the top judges repeatedly, a multi-time outstanding judge winner, our presider, Judge Stephen Noodleman.
Hi, everybody. Stephen Noodleman here. I am, I guess, your resident elder statesman. I'm practicing law in New York, New Jersey for the past 30 years. I was not involved in mock trial as a student, but I have been judging it for about the past 10 years on both the college and high school levels. So I'm looking forward to a very good competition. And as everybody said, have fun and do your best.
That said, Judge Noodleman, the floor is yours. Let's get this ball rolling.
Okay, let's call a case to the estate of Arthur Henley versus Elias Hornby. I'm Stephen Noodleman. Our scoring judges, look at the buttons at the lower left of your screen. Remember to keep your audio off till the end of the trial. You should also have your video, hiding all non-video participants. Okay, now we have people keeping time for each team. Hopefully you've got a timekeeper to prepare the case. And this is going to be an abridged format. One direct across the closing, all leads together, can't exceed 30 minutes aside. Let us have the appearances of the attorneys, please.
Yes, Your Honor. Good evening. My name is Christiana Garcia, and today joined by my friend and colleague, Elizabeth Liu.
Hello, Your Honor.
Hello.
We represent the plaintiff in this case, the estate of the deceased, Arthur Henley.
Okay, and the defense?
Yes, Your Honor. Good evening, Your Honor. My name is Anya, and today, joined with my co-counsel, Miss Vivian May.
Good evening, Your Honor.
Good evening.
Together, we represent our client, Dr. Elias Hornby.
Okay, does the plaintiff have any preliminary matters they wish to bring to the court's attention?
Yes, Your Honor. I'd also like to note that we're joined by our legal intern, Crystal Dang, who will be observing us throughout today's trial.
Good evening,
Okay.
Your Honor.
Good evening.
As for pretrial matters, first, we'd like to bring the court's attention to Stipulation 13. Andy Parr is duly appointed and legally recognized as the executor of Arthur Henley's will and estate.
Okay.
And with that, Your Honor, we'd also like to invoke Rule 603 and 615, the constructive sequestration and swearing in of all witnesses, bearing party representatives, and Andy Parr will be our party rep.
Okay, anything else?
Yes, Your Honor. During our meet and confer with the defense, both sides agreed to pre-admit Exhibit 9, a photo of the deceased, without objections.
Okay.
And with that, Your Honor, we're ready to kick things off.
Okay, let's see if the defense has any preliminary matters.
Yes, Your Honor. We'd like to first designate Dr. Elias Hornby as the defense's party representative.
Okay.
And next, we'd like to invite the court's attention to case law Minerva v. Rickman, which states that in wrongful death cases, a physician or medical practitioner is not required to guarantee a successful outcome for the patient, nor is an error in judgment automatically considered a breach in the standard of care. The specific wording is on screen.
Okay, I see it.
With that, the defense is also ready to go.
Terrific. All right, we're going to hear opening statements. Everyone make sure they're in the speaker view, button in the upper right of your screen. Attorneys, please remember to mute your audio. Any other attorneys speaking. And with that, Ms. Garcia, take it away.
Yes, Your Honor. Her shortcut cuts a life short. It's a busy day at a hospital. Nurses rush from patient to patient, and in one, a doctor named Elias Hornby is on duty treating a patient with low heartbeat and high blood pressure. It's a routine case. Doctors treat with the right protocol and the right drug. But today you'll learn that in a rush to reach her next patient, Dr. Hornby ignores protocol, telling an unqualified intern to fetch a syringe of drugs. She doesn't watch and fill it. She doesn't confirm what's inside. In that moment, she chooses to sacrifice safety for a shortcut. Picking it up, injecting it straight into the patient's bloodstream instantly. The patient is exposed to a deadly overdose of the wrong drug called ketamine. Moments later, the patient collapses, his breathing grows shallow. He dies. Because the intern grabbed the wrong drug and the doctor skipped the safety check. This is Arthur Henley, the husband, friend, and father. And on February 16th, 2023, his life was cut short because the doctor's shortcut. And that's why his estate is suing Dr. Elias Hornby for two things: medical malpractice, which means the defendant owed Mr. Henley proper care and failed to meet that standard, causing his death, as well as wrongful death, meaning the defendant's actions caused his death and his estate was directly harmed. We'll meet our verdict by proving each element more likely than not, with two facts: the slip-up and her shortcut. First, the slip-up. A frequent hospital visitor will testify the defendant knew this unqualified intern had a history of Grey's Anatomy level slip-ups, like filling syringes with the wrong drug. Yet, you'll learn today that this defendant still trusted him to fill a syringe that had Mr. Henley's life in his hands. So second, you'll learn about the shortcut. You'll learn from a drug expert that trusting this intern was a shortcut that broke protocol. And you'll see that because this defendant failed to supervise, failed to verbally confirm, failed to physically confirm the drug, Mr. Henley was injected with the wrong one. Her shortcut cut a life short. Now, folks, in a moment, we expect the defense may claim this wasn't malpractice, it was the intern's mistake. But today you'll learn the real mistake, the real shortcut, the malpractice. Was this defendant trusting an unqualified intern to do her job? Today, it's your job as jurors not to take shortcuts. It's your job to take looks at evidence and the facts of this case. And when you do, we expect you'll find the defendant liable because her shortcut cut a life short. I appreciate your time.
Thank you, Ms. Garcia. Very good. Can we now get the opening for the defense?
Yes, Your Honor.
Please-
May I proceed?
Please proceed. Yes.
Yes, Your Honor. The hospital mishandled the medicine. It's February 16th, 2025, and Langford Hospital is bustling with activity. Patients are milling around, doctors are scrambling, and the staff are tired and overworked. And in the middle of it all is an intern named Finley Riveras. Now, she's made mistakes before, but she's not worried because she knows that the hospital will let her keep her job no matter what happens. So on that day, she's instructed by the doctor to fill a life-saving injection. Don't mess this up. But she does. She gives it to my client, who then injects it into Mr. Henley. Mr. Henley dies because of that injection. Members of the jury, it wasn't Dr. Hornby's shortcuts that cut his life short. It was the hospital's, because the hospital mishandled the medicine. And so today, by accusing Ms. Hornby of medical malpractice and wrongful death, the plaintiff took on a burden to prove more likely than not that Ms. Hornby's actions caused the death of the victim. And now, as the defense, we don't share that burden. We don't have to call any witnesses or show you any evidence. But we're going to. Because there's 3 simple facts that the plaintiff simply cannot answer. Mislabel, the mistake, and the mishandle. And so first, the mislabel. Today, you'll learn about a bottle of medicine that had the wrong label. You'll learn that that vial injected into Mr. Henley was labeled as a harmless drug, while actually containing a lethal dosage of another drug. And you'll learn that both substances look nearly identical to each other. So second, the mistake. Today, you'll hear about an incompetent intern who filled Mr. Henley's file. You'll learn that this wasn't the first time the intern has made a mistake. Eyewitnesses from the day of the incident will tell you how the intern was confused, repeating instructions, and admitting that she's gotten syringes wrong before. So finally, the mishandle. Today, my client will take that stand and tell you how she tried to get that intern fired. But a lawyer will reveal how the intern could keep her job. That lawyer will tell you how hospital administration only kept that intern because the intern's mother had connections within the department. And you'll learn about a case of corruption that cost Mr. Henley his life. The hospital mishandled the medicine. Ms. Garcia is right. There was a mistake. But that mistake wasn't my client's fault. And that's why, at the end of today's trial, my co-counsel, Ms. Anya, she'll come before you again and she'll ask you to reach the only just verdict. Because the hospital mishandled the medicine. Find Elias Hornby not liable. Thank you.
Thank you, Ms. May. Okay. Now, before the plaintiff calls its first witness, ask everyone to please switch to the gallery view. Button is in the upper right of your screen. This allows attorneys and witnesses to be seen at the same time. And with that, does the plaintiff have a witness?
Yes, Your Honor, we do. At this time, we call our party representative, Ms. Indelia Parr, to the stand.
Okay, very good. Thank you, Ms. Slew. Please proceed.
Yes, Your Honor. Good evening, ma'am.
Hello, darling.
Please introduce yourself.
My name is Andelia Parr, but don't let these grays fool you. I'm still young at heart, so call me Andelia.
Miss Indelia, what do you do for a living?
I sing, I act, and I do this thing called improv at my senior center every Thursday. Some folks over there call me a Broadway granny.
Miss Indelia, why aren't you at the improv club today?
Well, as Miss Christiana said a moment ago, I'm bringing forth a suit. Not like the one you're wearing, although you look very sharp, darling, but a lawsuit for lawyers.
Thanks for the compliment, Miss Indelia. You look great yourself. But moving on, why are you bringing a lawsuit?
Well, earlier this year, my friend Arthur Henley, his life was cut short after being treated by a doctor for his high blood pressure and his heart. And I saw it all happen.
So, do you know the defendant in today's lawsuit?
Yes, I do. That's the doctor who treated my friend Arthur on the day that he passed.
Your Honor, at this time, we ask for the defendant to turn on her camera for witness identification purposes.
Okay, have that happen.
Could you please identify the defendant by an item of her clothing?
Sure. She isn't wearing a bright white lab coat anymore, but she's wearing black. Reminds me of the Addams family. The family that, they always wear black with that girl, what's her name? Tuesday? No, Wednesday? It's something like that.
Your Honor, let the record reflect that Miss Indelia has accurately identified today's defendant.
Okay,
Let's walk through what happened the day Mr. Henley's life was cut short. How did your day start off?
Arthur and I started off by grabbing this very nice brunch at one of those singing diners, just like the ones on Broadway. Our waitress, she was an absolute sweetheart, but let's just say her voice belonged at an Applebee's, not on stage.
What did you do after you left that singing diner?
We went to the hospital for Arthur's treatment. I was there for moral support.
When you got there, what was the state of the hospital?
There were a lot of people there. In theater they say break a leg, but honey, at my age, that's not a metaphor. It's just a medical bill. So I make sure to walk very slowly.
When did Mr. Henley get seen by the defendant?
In the afternoon, much faster than I expected. But that's when Arthur told me that the doctors were getting interns to help him out.
Did the defendant have an intern?
Precisely so. From what I saw, Dr. Hornby was getting help from someone Arthur said was an intern, as she was getting the syringe of drugs into him.
All right, now, today, Ms. May said that it was the hospital that mishandled the medicine. Let's walk through and see if that's true.
The stage is yours, ma'am.
Thank you, Miss Indelia. Stating for the record, we'll be screen sharing a visual aid. Miss Indelia, right now, I'll list out some tasks, and if you could tell the members of the jury whether or not the defendant performed those tasks, that'd be great.
Sounds perfect to me, darling.
All right, so first, retrieve the syringe.
No, she received it from her intern.
Fill the syringe.
No.
Check the syringe to make sure there wasn't any mishandling.
No, ma'am.
Objection,
Here
Your Honor.
Yes, Ms. May, what is the basis for your objection?
Yes, Your Honor, lack of personal knowledge. May I explain?
Sure.
Yes, Your Honor. The witness on stand would not know whether or not Miss Hornby checked the syringe. And that's for Miss Hornby to tell us. The witness can't tell us if Miss Hornby checked that syringe outside the view of this witness.
Your Honor, may I be heard?
Yes.
Your Honor, in this case, Miss Indelia isn't testifying to at all whether or not the defendant checked the syringe. Instead, she's just saying to her knowledge what she observed throughout her entire time at the hospital room with the defendant. She didn't see the defendant check the syringe. If Your Honor would like, we can offer a limiting instruction for the jury to know that this is purely what Miss Indelia observed and not everything. But in this case, Your Honor, we still believe that this is admissible.
What do you say about that, Ms. May?
Your Honor, we're perfectly fine with that limiting instruction as long as that limiting instruction also goes on the visual aid opposing counsel has up right now. Because as Your Honor can see, the very bottom line of task says check syringe. Now, Your Honor, if I may proffer.
Well, hang on. I want to make sure I'm on the same page as you, Ms. May. Are you saying that you have no objection to the retrieving the syringe and the filling syringe part? So those top two checks you have no objection to. It's an issue that you have is with the third item.
Yes, Your Honor.
Okay. Yeah, no, there's no need to go any further. The objection sustained to the extent there'll be a limiting instruction given to the jury, such that as it relates to checking the syringe, this is what is based on Ms. Parr's observation. Not that it in fact occurred or did not occur. It just says that Ms. Parr did not see it occur. And that's how we'll deal with the checking the syringe. Okay?
Yes, Your Honor.
All right, continue, Ms. Liu.
All right, now, Miss Indelia, you just said the intern 3 times in a row. Did you not see the defendant do any of these things?
No, I didn't.
What happened after the defendant didn't take steps to make sure there wasn't mishandling, as you saw?
Arthur got the shot in his arm. After we left to go watch his little bundle of joy, that's his granddaughter, as nun number 7 in The Sound of Music.
Did he ever get to see his granddaughter perform?
No, ma'am. Walking out of those big hospital doors were one of the last things I got to do with Arthur.
What do you mean it was one of the last things you got to do?
One moment, Arthur had this big smile on his face. He was cracking a joke and talking about how his granddaughter was a little mini Meryl Streep. But then he started turning pale. He started shaking.
After he started shaking, what happened?
He collapsed on the ground. He was just on the floor shaking. And then some of the hospital workers came out and got him onto a stretcher to go back in.
What did you do?
I could barely breathe. My hands were shaking. My chest felt tight. I was stuck in the waiting room, and then after what felt like years, a doctor came out very quickly. And she told me that Arthur had passed away.
My condolences, Miss Andelia. We appreciate you so much for sharing today. Your Honor, at this time, no further questions.
Okay, thank you, Ms. Liu. Ms. May, cross-examination.
Yes, Your Honor. May I proceed?
Please proceed.
Yes, Your Honor. Good evening, Miss Andelia.
Hello, ma'am.
I just want to start by saying I'm so sorry for your loss. I just have a few quick questions for you, all right?
It looks great. So does your purple suit, Arthur's favorite color.
Thank you, ma'am. Now, Miss Andelia, you're not a doctor, are you?
No, I'm not.
You don't treat people.
No, I don't.
You treat animals.
Yes, before I found my career on stage.
So, Miss Andelia, you don't prescribe medication for people, do you?
No, I don't.
You can't tell us what's good for people?
No.
And you can't tell us what people can or can't be injected with.
That's right, ma'am. The closest I've ever come to being a doctor is playing one in my improv class.
Oh, ma'am, the truth is, you didn't even know what treatment Arthur was getting that day.
No, I didn't. Not that day.
Ma'am, I'd like to talk about that syringe you saw. Now, let's be clear. You don't know what was inside that syringe, do you?
No, I just know who filled it and who gave it to Arthur.
Ma'am, that wasn't my question. You don't know what was inside that syringe.
I heard it from Miss Garcia today, but that day, no.
So, ma'am, you couldn't tell us the color of that liquid?
No, I can't.
You couldn't tell us what that drug was?
No, not for 100%.
Oh, you know, ma'am. Is that an intern filled it?
Yes, yes, I do.
Now, ma'am, moments ago on direct, you described that intern as stuttering.
Yes, she was nervous like an actor who's getting ready to open her first show.
Exactly. She was nervous and she was shifting around.
Yes.
Now, you even heard other doctors warning that intern not to mix up the medication.
I did. That's what I heard.
And that intern responded, that only happened last time. Not again.
Yes, from what these old ears heard.
Ma'am, let's talk about that intern and see who actually mishandled the medicine, because you know that that intern's made a mistake before.
Yes, from what I heard from other people only, but yes, I do.
Let's turn your attention to Dr. Hornby, because when the intern filled that vial, well, ma'am, you were worried, weren't you?
I was. I didn't want my friend to get anything that he wasn't supposed to get.
You didn't want your friend to get anything he wasn't supposed to get, so you brought your concerns up to Dr. Hornby.
Yes, I did.
And, ma'am, Dr. Hornby told you that that medication has been triple checked.
Objection, Your Honor, hearsay.
Your Honor, response if I may?
Ms. May, what is your response to that?
Yes, Your Honor, we're using this for the effect on the listener, as it goes to show the effect that this statement had on Miss Anya Parr here.
Your Honor, response?
Sure.
Your Honor, we would ask for Miss May to specifically say what other action Miss Andelia took as a direct result of the defendant saying these words.
Okay, Ms. May, what do you say about that?
Your Honor, that action is not needed because, as we're going to show you, after hearing these words, Miss Andelia Parr here felt reassured enough to let this injection process continue. That goes to effect on the listener.
That does. The objection's overruled.
Yes, Your Honor.
Ma'am, I'm going to ask my question again. Dr. Hornby told you that that medication has been triple checked.
Yes, that's what she told me, but I thought of it like a narrator. You hear them, but you don't know where they are, and you don't know what they did or didn't do.
Ma'am, bringing you back to my question, Dr. Hornby told you that medication has been triple checked, right?
Yes, that's what she told me.
Now let's make this clear. You never saw Dr. Hornby act nervous, did you?
No, not from my observations.
You never saw Dr. Hornby hesitate?
No, I didn't think so.
What you did see was a nervous intern.
Yes, she seemed nervous to me.
Now, Miss Andelia, I know this might be difficult for you, but you loved Arthur Henley like a brother, didn't you?
Yes, I did.
You want justice for him.
Of course I do.
In fact, ma'am, you are decided that Dr. Hornby's responsible.
From what I observed that day,
Because, ma'am, you had a bad feeling about Dr. Hornby.
yes, I did from what I observed that day.
Thank you, ma'am, for your time today. Your Honor, I have no further questions.
Thank you, Ms. May. Ms. Liu, any redirect examination?
Yes, Your Honor.
Please proceed.
Miss Andelia, Miss May asked you a lot about what you don't know, so let's pivot and talk about what you do know. On the day Mr. Henley's life was cut short, what do you know about that day?
I know Arthur was acting completely normal. And after...
Ms. May, what is the basis for your objection?
We didn't explore any line of questioning on what Miss Andelia did know. We only explored what she didn't know.
What is your response to that, Ms. Liu?
Yes, Your Honor, we'd say that Miss May opened the door. On cross-examination, she talks about whether or not Miss Andelia knows the intern was nervous. She talks about whether or not Miss Andelia knows this intern had slipped up before. Your Honor, surely Miss May has opened the door to talk about what Miss Andelia knows about that day when she established facts about this intern.
Yes, I tend to agree with that, Ms. May. So the objection is overruled. Continue,
Yes,
Ms.
Your
Liu.
Honor.
Yes, Your Honor. Miss Andelia, you continue your response if you want to.
I believe I said Arthur was acting normal at brunch, and at the hospital I saw the intern fill the syringe and Dr. Hornby come in and give the shot, and then Arthur passed away.
Thank you so much again for your testimony today, Miss Andelia. Your Honor, no further questions.
Okay, Ms. May, any recross examination of this witness?
No recross, Your Honor. We're going to let
Very-
Miss Andelia get back to her improv classes.
Very good. Ms. Parr, you're excused. Thank you very much. Does the plaintiff have any other witnesses?
Yes, Your Honor. We call Dr. Alex Zuzak to the stand.
Okay, very good.
May I proceed?
Please proceed, Ms. Garcia.
Hello.
Good day, ma'am.
Please introduce yourself to the jury.
Of course. Good day, everybody. Name's Alexander Susak.
What do you do for a living?
I'm hospital's director of clinical and forensic pharmacology. I track down medicinal mistakes and hospital pharmacy slip-ups.
How did you get into this line of work?
Well, I grew up down in Owensboro, in Kentucky. Now there they had these great tobacco farms. I used to take the leaves and soak it in chemicals, dry them, and that eventually sparked my interest in chemistry.
Since that interest was sparked, what does your educational background look like?
Well, I hold a bachelor's degree in chemistry, and I later earned a master's and the title of doctor in forensic toxicology.
Why are you here?
I was asked and retained to answer the question of whether Dr. Hornby took shortcuts with the protocol of administering drugs to their patient suffering from high blood pressure and low heartbeat. I determined if his care directly caused Mr. Henley's death.
What materials did you review as part of your investigation?
I reviewed medical records, witness statements, and the syringe used on Mr. Henley.
Did you use a method?
I did. I used the C method, and that method helped me see the facts of the case, and I bought a visual aid for y'all to see today.
All right, well, let's see it. Stating for the record, we'll now be screen sharing a visual aid created by Dr. Zuzak. What does your method stand for?
Well, the C method stands for secure, examine, and then error in treatment.
Is this method widely accepted in your field?
It is the gold standard in my field, ma'am, and I reliably applied it to the facts and data of this case.
All right, sir, and throughout your investigation, after looking at all the evidence, was there anything to point that there was an error or mishandling of the syringe of medicine?
No, ma'am. The syringe was not mislabeled. Rather, I found evidence of the defendant mishandling the syringe.
Well, let's see if the test reveals why the defendant might have mishandled the syringe. Starting in the S in your method, what did you secure?
Start, I secured the syringe used to administer this drug in Mr. Henley's bloodstream and tested it.
What is this?
That appears to be the syringe in the case.
Is it fair and accurate?
It is.
Your Honor, we move to enter this exhibit into evidence.
Ms. Lowe, any objection?
No, Your Honor.
Okay, Exhibit 3 is accepted into evidence.
Yes, Your Honor. Now, doctor, what test did you run on this syringe?
I used a UV light detector on the syringe to identify the drug traces left behind. I actually bought a visual aid to demonstrate a simplified version of how this test works for the folks on the jury.
Take it away, doctor.
All right, if you'll allow me to just turn on this very nice setup I got on the side. Turn this camera around. Can y'all see it all right?
Yes, sir.
Perfect. Now see, I got this UV light. Think of this as a chemical flashlight for you. Some drugs shine brightly under it, some not at all. Each reaction is unique, like a chemical fingerprint.
What drugs did you test?
Well, here I have two syringes representing the drugs involved in the case. This one labeled L for lorazepam, this one K for ketamine.
How did you test them?
Well, first I examined this syringe labeled L for a glow, and as you can see, it did not. If the correct drug had been used to treat this low heartbeat and high blood pressure, the residue would have glowed under the light, but it did not.
What about the other drug?
Now, this K syringe, under the UV light, it's got this glow. This glow shows there were chemical traces of ketamine in the syringe, which means the wrong drug was given to Mr. Henley.
Your Honor, at this time, we invite the court's attention to stipulation 14. Both parties stipulate that ketamine was found in Arthur Henley's system post-mortem.
Okay.
Going to the E in your C method, let's examine if ketamine is what cut his life short. Did you review an autopsy?
I did.
What did it say?
It stated the cause of death was acute ketamine toxicity.
After following your C method,
Yes, Ms. Lowe, what's the basis for your objection?
As to hearsay, Dr. Zuzak bringing up the exhibit that has not been entered yet, the autopsy report.
Well, I don't know if he brought up the exhibit per se, but your comment is that he's talking about the autopsy, which is.
Yes, Your Honor.
I understand. Okay. Ms. Garcia, what do you have to say about that?
Yes, Your Honor, this isn't hearsay under Rule 703, basis of an expert opinion. As we've already laid the foundation for Mr. Zuzak to be an expert, he had reasonably applied these facts and data in this case, and that specific autopsy report helped him determine that ketamine is what cut Mr. Henley's life short. Hence, it would be under the basis of an expert, which is admissible under 703.
Response, Your Honor.
Yes, Ms. Lowe, what's your response?
Your Honor, Rule 703 doesn't allow experts to simply state hearsay word for word, putting conduits to let hearsay in. Your Honor, 703 is only if Dr. Zuzak is really basing a conclusion off that autopsy report. But as it's already been well established throughout this examination, through stipulations, through witness testimony, that there was ketamine in Mr. Henley's bloodstream, not lorazepam, it is absolutely not necessary to bring in this line from the autopsy report for Dr. Zuzak to reach his conclusions.
I agree, and the objection sustained.
Yes, Your Honor.
That testimony is stricken and the jury will disregard it. Continue, Ms. Garcia.
Sir, let's talk about the potential shortcuts the doctor took when handling the drugs. What are the protocols set in place when doctors treat patients with drugs?
Standard protocol for physicians like the defendant requires confirming a syringe's contents before injection.
Why?
Some drugs look alike but differ in scent, viscosity, so on and so forth. Now, without verification, such mistakes can be fatal. So making confirmation checks is vital for patient safety.
In this case, who filled the syringe of drugs?
It is my understanding that Dr. Hornby instructed an intern to fill the syringe.
Was there any evidence to suggest this intern was qualified?
No, ma'am. And a lack of evidence suggests the intern wasn't a qualified intern capable of handling deadly drugs.
Well, based on the materials you reviewed, was there evidence the defendant supervised the intern?
No, ma'am. Throughout my investigation, I found no evidence of supervision between the intern and the doctor.
Was there any evidence that the defendant physically inspected the drug?
No, ma'am. Though the doctor claimed the medication was verified, there is no physical proof showing the defendant actually confirmed the drug contents before injection.
Well, did the defendant take any steps that day to ensure the intern didn't make a mistake?
No, ma'am. Again, though I am aware Dr. Hornby claims she checked, there was no physical evidence to support that claim.
So, doctor, what's your conclusion on this case?
The defendant failed to confirm the drug before administration, causing Mr. Henley to receive the wrong drug, which tragically cut his life short.
Thank you, doctor. At this time, Your Honor, I have no further questions.
Okay, thank you, Ms. Garcia. Ms. Lowe, cross-examination.
Yes, Your Honor. Good evening, Dr. Zuzak.
Good day, ma'am. Gotta say, you're looking real dapper today. How you doing?
Doing well, thank you. Let's begin with a few things we can agree on. Because we can agree that Arthur Henley was injected with the wrong substance.
He was.
We can agree it was ketamine, not the lorazepam he needed.
You have that right.
We can even agree because of that injection, Arthur Henley died.
Unfortunately so.
But let's see if it was the hospital who took shortcuts when they mishandled the medicine. Sir, I'm holding a book right now, right?
Oh, yes, I believe actually my son used to read that book. Great book. You are.
And now if I stuck this post-it note on it that says plant, well, I've still got a book in my hand, right?
Yeah, you do. That's how books are.
This book didn't suddenly become a plant?
No, it did not.
That's because a book isn't a plant.
Right.
Sir, it's fair to say this book is mislabeled.
It is. Actually, maybe the title isn't, unless you got that sticky note on there.
But it is mislabeled right now.
Right now it is.
And that is exactly what happened in today's case.
Objection. As to 403, more misleading than it is probative. May I be heard?
Yes, go ahead, Ms. Garcia.
Your Honor, Miss Law just held up a book and put a sticky pad to it, saying that it was mislabeled. Your Honor, in this case, we have a good faith basis to believe she's going to imply that the medicine syringe was mislabeled, similarly to how she mislabeled the book. But Your Honor, as we know, medicine is nothing like sticky notes or books, so it's misleading the jury into thinking that this is how the medicine was mislabeled.
Ms. Law, what's your response to that?
Your Honor, as we all know, 403 has an extremely high bar. It's got to be substantially more prejudicial. Your Honor, in this case, there is nothing prejudicial about using this analogy. Rather, it has a lot of probative value to demonstrate to the members of the jury how the bottle was mislabeled and how that can relate to something a little bit easier to understand. It's simply for the benefit of the members of the jury, and we're not implying any facts that are wrong or anything of those sorts.
Your Honor, may I be heard?
No, it's not necessary, Ms. Garcia. Your objection's overruled. To the extent you have an issue with the use of the analogy, you're welcome to raise it on cross-examination with the witness, or correction, on redirect examination with the witness. Okay?
Certainly, Your Honor, we intend to do so.
Go ahead, Ms. Lowe.
Yes, Your Honor. So, just to be clear, this book with the sticky note is mislabeled.
Correct.
And that is exactly what happened in today's case.
Oh, well, ma'am, that's not true. There was no book and no sticky note in my case.
True, there was no book or sticky note, but the hospital had mislabeled medicine.
That is my understanding.
They kept a bottle of ketamine with the wrong label, lorazepam, stuck on it.
That's what my investigation found.
Doctor, that's dangerous.
It is, and that's why those doctors should be double-checking everything.
Doctor, keeping a bottle of mislabeled medicine, that can lead to deadly consequences.
It can, just like without double-checking something. You have that right.
Because ketamine and lorazepam, they look the same.
They do. Aside from viscosity and scent, they look alike.
They're both colorless substances with almost no difference.
Aside from viscosity and chemical compounds, you have that right.
Well, when you hold them up next to each other, it's pretty hard to tell them apart, even with the viscosity.
Correct.
Well, let's now talk about the second shortcut the hospital made to mishandle the medicine.
Objection. As to attorney testify, Miss Liu just stated that the hospital took a shortcut. Your Honor, she's specifically stating that the hospital did something and it's asserting a fact onto the record.
Response, Your Honor?
Yeah, let me hear your response, Ms. Lowe.
Your Honor, throughout this entire trial, opposing counsel has already used their theme within headers. They've implied things in their headers. And additionally, I've said, let's see if there's a talk about the second shortcut. It's not actually implying that the fact did happen.
Right, but you had every opportunity, though, Ms. Lowe, to object to the question when Ms. Garcia might have done that. If you didn't raise an objection, then I'm not going to stop her. I happen to agree. The question as asked is prejudicial, so it's stricken. You may re-ask the question without the introductory portions, if you want to call it that. Okay?
Yes, Your Honor. Well, let's talk more about someone else who was involved. Because, Doctor, there was actually an intern involved in this whole process.
There was one by the name of Finley Riveras.
An intern that filled the syringe?
Correct.
Now, sir, this wasn't the world's best intern, was it?
No, I'm aware they frequently knock things over, frequently made mistakes. You have that right.
The intern didn't just knock things over. The interns filled a syringe with the wrong substance.
They did, ma'am.
Dr. Hornby wanted to fire her for this mistake.
They did.
Objection,
but it-
as for speculation.
Oh, okay. What do you say about that, Ms. Lowe?
Your Honor, this is cross-examination. If Dr. Zuzak doesn't know, he's free to say so. But in addition, it's already been laid on the record that Dr. Zuzak reviewed all the other witness statements, and it clearly says in Dr. Hornby's statement that she wanted to fire the intern.
Yeah,
Your
the
Honor, may I
problem.
be heard?
No, Ms. Garcia. What happened here is that unfortunately, Dr. Zuzak, maybe he jumped the gun, but he made it clear that he knew the answer. So I would not call that speculation. The objection's overruled.
Yes, Your Honor.
Why don't you re-ask that question?
Yes, Your Honor. And sir, Dr. Hornby wanted to fire the intern for making that mistake.
Yes, but it is my understanding that the hospital did not fire the intern.
Exactly. The hospital, it didn't let her fire the intern.
Right, because of some sort of unverified parental connection between the intern and the hospital.
Sir, it's not unverified parental connections. There was a connection between the intern and the hospital, and that is how she kept her job.
I'm aware that was in Hornby's statement, though I found no other evidence corroborating those claims. But that's a yes to your question.
It's a yes. The hospital wouldn't let Dr. Hornby fire the intern because she had connections.
Correct.
And finally, sir, let's see if you took any shortcuts when investigating this case. Because you only had access to a fraction of the evidence.
No, ma'am. I conducted independent testing, even reviewed 5 exhibits, all the witness statements. That's a no.
Sorry, you're saying no, but you didn't review all of the exhibits?
Correct. The other 5 were dealing with financial statements, a koi pond, and a picture of the deceased. So that's a yes to your question.
Yes, you didn't review all the exhibits.
Correct.
You didn't interview the intern or any of the other hospital workers.
I did not.
The only materials you did investigate was what the plaintiff counsel gave you.
No, ma'am. In fact, the syringe was something that I independently seeked out and tested, though it was on their behalf.
It was on the plaintiff's behalf. That's how you got your evidence.
Correct, ma'am.
Thank you, Dr. Zuzak. Nothing further, Your Honor.
Thank you, Ms. Lowe. Ms. Garcia, any redirect examination?
Yes, Your Honor.
Go ahead.
Dr. Zuzak, Miss Lowe just showed you a book and a sticky note implying that the hospital mislabeled the medicine. Sir, even if that was true, in what ways could the doctor have known the medicine was mislabeled?
Well, like I just explained, ketamine and lorazepam have significant chemical but also physical properties that are different from one another. One of them being the viscosity, the other being the scent, which is very distinct between the two. Now, even if they couldn't tell, that scent should have signaled something was off.
Thank you, Dr. Zuzak. Your Honor, at this time, I have no further questions.
Thank you, Ms. Garcia. Ms. Lowe, is there any recross examination?
No recross, Your Honor.
Okay, thank you, Dr. Zuzak. You're excused.
Your Honor, with that, we rest our case in chief.
Okay. Would the attorneys like to take a break of some sort?
We'd be amenable, Your Honor.
Okay. How long would you like? 5 minutes, 7 minutes?
Your Honor, we understand this Zoom platform brings judges from all around the world, so we understand that we're on different time zones and it's getting pretty late, so whatever is fine with us.
Ms. Lowe, how much time do you want? 5 minutes or 7 minutes?
5 minutes sounds great, Your Honor.
Fine. It is now 14 minutes after the hour where I am. We will be back here at 19 minutes after the hour. Okay?
Sounds
Excellent.
good.
Thank you. All right, we're back for the break. And we're at the point now where we will hear the defense. Ms. Lowe, please call your first witness.
Yes, Your Honor. We call Jules Martin to the stand. Good evening, ma'am. Could you introduce yourself to the court?
My name is Jules Evan Martin.
What do you do for a living?
I'm a licensed estate attorney here in Tilly.
And where are you from?
I'm from Britain. My father was a shoe shiner and my mother was a psychic. She had crystal balls and tarot cards, the whole deal.
So how did you get into law?
Well, since I was a kid, I've wanted to be a fortune cookie writer. I've always wanted to tell people things about the future, like, I can see into your future, you're going to do well on your next test. But once my mum told me about how little fortune tellers make, I decided I'd be better off as a lawyer.
All right, ma'am. So what do you do as a lawyer?
Well, a few years back, I started my own company, Martin and Associates, and we specialize in wills and trusts. So our clients are often people who are inheriting money, stuff like that.
Why are you here in court today?
Pardon me. I was Arthur Henley's estate attorney, and we were actually close friends. I'm here to tell you more about his will and what happens next.
Well, before we talk about that will, let's take a look at the relationship between Mr. Henley and Dr. Hornby. Do you know Dr. Elias Hornby?
Of course. She's my daughter's doctor and helps with her anxiety. Actually, that was why I recommended Arthur to her in the first place.
What do you mean by that?
Arthur told me he's been having some heart issues. Honestly, I think there's nothing a good old cup of English tea wouldn't fix. But turns out he also needed... Pardon me? He needed lorazepam as treatment. Since my doctor was also being treated with the same thing, I told him Dr. Hornby was a good fit.
Did Mr. Henley have any previous interactions with Dr. Hornby?
Yeah, Arthur was Dr. Hornby's uncle, actually. They weren't close and had some disagreements in the past.
What do you mean by that?
Over money and Dr. Hornby's medical school debt. They worked it out. Arthur paid most of it and Dr. Hornby finished it off.
So did Mr. Henley start getting treatment from Dr. Hornby?
Yes, for almost a year. Arthur would regularly visit Dr. Hornby to receive lorazepam injections. Nothing went wrong.
And have you ever personally been to the hospital Dr. Hornby worked at?
Naturally, I visited several times, mostly for my daughter, but sometimes for Arthur too.
Well, let's see if the hospital mishandled the medicine. Can you tell us more about that hospital?
Right. It's called Langford Hospital. It's a good hospital, just understaffed. I noticed doctors like Dr. Hornby were often stretched thin.
Objection, Your Honor. Improper expert opinion. May I be heard?
Sure, Ms. Liu, go ahead.
Your Honor, Ms. Martin just testified that the hospital was understaffed. There's no way for this lawyer, she's not a doctor, she's not trained in medical protocols. She can't specifically tell us as to what constitutes overstaffed. She doesn't know the exact ratios that should be happening. She doesn't know how hospital operations work. And therefore, Your Honor, she's not qualified to testify as to whether or not this hospital was definitively understaffed.
Response, Your Honor.
Okay, yes, Ms. Lowe, what's the response to that?
Your Honor, we didn't ask Ms. Martin to make any expert conclusions about the hospital, how the hospital is run. Instead, we just asked her about her observations. And she said things like, I noticed doctors like Dr. Hornby were stretched thin. Previously, foundation has been laid on the record that Ms. Martin is familiar with the hospital and that she has visited before, and she's just giving the jury her rationally based perception based off what she saw.
Ms. Lowe, what's your response to that?
Yes, Your Honor. We're not objecting to the question Miss Lowe referenced. We're perfectly fine with this question. However, Your Honor, Miss Martin stated verbatim, the hospital was understaffed. In this case, we're okay with her talking about Dr. Hornby being stretched thin, about how the hospital is busy, but in this case, asserting onto the fact of the record that the hospital was understaffed without having knowledge into hospital operation or hospital protocol is still an improper expert
Yeah,
opinion.
no, well, it's certainly there's a lack of foundation for this witness to testify as to the staffing of the hospital. So to that extent, the objection is sustained. Ms. Lowe, I understand what you're saying, but that's not what the witness testified. So, you know, if I follow what you're saying, the witness said, but the way I heard it from Ms. Liu, the witness is not capable or competent to make that statement as it was testified to. So that's why the objection sustained. Continue.
Your Honor, motion to strike.
Yes, the testimony is stricken and a jury will disregard it. Okay,
Yes, Your
continue,
Honor.
Ms. Liu.
Yes, Your Honor. Ms. Martin, can you tell us more about what you noticed from the hospital?
Right. Like I said, it's called Langford Hospital. Doctors like Dr. Hornby were often stretched thin.
What do you mean by that?
You know, always juggling between different patients and paperwork. I have spoken to other patients before. There's been documented syringe mix-ups or rushed appointments. Both doctors and interns are doing more than they should.
Ma'am, you just mentioned interns. Did Dr. Hornby have any?
Yes.
Do you know any of them?
One in particular, Riveris. She was an intern under Dr. Hornby and not the best.
Not the best? How come?
Well, she made mistakes. You know, knocking things down, even forgetting to sanitize the syringe once. Dangerous mistakes.
Did the hospital fire this intern?
No. Riveris was still working with patients up until Arthur's death.
Well, ma'am, were you at the hospital that day?
No, I wasn't. I found out from Arthur's wife about what happened.
Let's talk more about the will you're familiar with. Ma'am, did you write Mr. Henley's final will?
Yes, I personally drafted it, and it was signed and notarized sometime in April this year.
Your Honor, stating for the record, the defense is now screen sharing Exhibit 1.
Okay.
Ma'am, do you recognize this?
Yes, this is a copy of the will.
And does it look fair and accurate from what you remember?
Yes, it does.
Your Honor, the defense moves to enter Exhibit 1 into evidence.
Any objection, Ms. Liu?
Yes, Your Honor, asked to hearsay.
Okay, Ms. Lowe, what's your response to that?
Your Honor, this meets the criteria under Rule 804A and B as the statement of an unavailable witness. First, under Rule 804A4, this declarant is considered unavailable if they can't be present at the trial because of death. Unfortunately, Mr. Henley has passed away and cannot testify today. And next, under Rule 804B4A, Mr. Henley's will is a statement of personal or family history because it talks about his personal and family assets that he will be passing on to his loved ones or friends. His will meets the requirements of 804.
Your Honor, may I be heard?
Yes, Ms. Liu, go ahead.
Yes, Your Honor. If the defense's tech could actually go to the last page of the will. Your Honor, right there, it says that the executor of the will is Andy Parr and that Jules Evan Martin, this witness, was the person who drafted the will. As this witness testified a moment ago, she was the one who personally drafted this will, not the declarant, not the deceased Arthur Henley. We understand that this is Mr. Henley's will. However, as this witness just testified, the declarant in this case isn't actually Mr. Henley. It's this witness, because this witness, as the estate lawyer, was the person who actually drafted this will. Your Honor, as she's testifying right now, she's certainly not unavailable.
Response, Your Honor?
I do want to hear the response to that, Ms. Lowe.
Yes, Your Honor. Just because Mr. Henley wasn't the one to type this out word for word doesn't mean that it's not his statements being made. Because on the
I say no more. I do agree with you, Ms. Lowe. Under that argument, this is Mr. Henley's last will and testament. That it was drafted or witnessed by other people doesn't change this being his thoughts that he approved, his requests, things of that nature, bequests. So to that extent, the objection is the objection is overruled, and we will accept Exhibit 1 into evidence.
Yes, Your Honor. Co-counsel, if we can go back to the first slide. Ms. Martin, can you tell the court about what this will says?
Yes. Arthur left his wife the family home, household items, and $300,000. His 4 children were each given equal shares of his remaining properties and accounts. He also donated his historical letters and book collection to the Tilly Historical Preservation Society.
Ma'am, does it say anywhere on this document that Arthur Henley left Dr. Elias Hornby money?
Objection, Your Honor, relevant.
Nothing at all.
May I be heard?
Yeah, say it again, Ms. Liu. You're objecting on the grounds of relevance?
Yes, Your Honor.
Okay, go ahead. Let's hear what's not relevant.
Absolutely, Your Honor. As Ms. Lowe just asked, she asked if the defendant was ever on the will. We believe that this question is going to rebut a potential motive of the defendant intentionally taking a shortcut to cut Mr. Henley's life short. In this case, Your Honor, it's not relevant because it's not the plaintiff's contention that there actually was any intentionality within the shortcut that the defendant took. Rather, Your Honor, the reason this is irrelevant is because in this case, no foundation has been laid in the plaintiff case in chief that makes it relevant for whether or not the defendant was on the will to be important, or rather relevant, in today's case, Your Honor.
Okay, I want to hear what Ms. Lowe has to say about that.
Yes, Your Honor. As we all know, relevance has a ridiculously low bar to meet. And Your Honor, just because the plaintiff counsel doesn't want to hear it, it doesn't mean that it's not relevant to this case today. Because Your Honor, it is the defense's contention through this that Dr. Elias Hornby has no motive at all to mishandle the medicine.
But the allegation, if I understand it, the claims in this case are based on negligence, not intentional torts or intentional wrongdoings. So therefore, why is the intent of whether, his motive, why is that relevant? If we're talking about something being negligent, meaning it was an accident, let's say, why do we care about the motive of being included or not included in the will?
Your Honor, we're keeping this in to preempt any potential plaintiff theories if they do want to bring up Dr. Elias Hornby's intent.
No, it's okay. I don't see it. The objection sustained.
Motion to strike.
It's stricken. I just don't see any basis at all for that in light of the fact that the claims in this case are predicated on negligence. So
yes.
Continue.
Yes, Your Honor. So Ms. Martin, just to be clear, can you tell us more about this will?
Sorry, could you repeat the question?
Certainly. Can you tell the court more about this will? Ms. Martin?
So sorry.
And can you tell the court more about the will? I don't know if my audio cut out or anything.
Right. Like I said before, The will only gave property to his wife and his 4 children.
Nothing further, Your Honor.
Okay, Ms. Blue, cross-examination.
Yes, Your Honor. May I proceed?
Please proceed.
Hello, Miss Martin.
Evening.
A moment ago, you said you enjoy predicting the future, right?
Oh, yes, I quite do.
But ma'am, in this case, you can't predict what happened to Mr. Henley, can you?
No, ma'am, I can't.
You'd have to know what happened.
Yes, ma'am.
And when it comes to what happened inside Langford Hospital that day, we can agree, you have no idea.
Well, I only know what Arthur's wife told me.
Right, so ma'am, we can agree that what happened inside Langford Hospital about hospital treatment and protocols, you don't know.
No, I don't.
All right, so let's pivot from the future and talk about the past. In the past, you've been to the hospital.
Yes, I have, for my doctor.
And as you mentioned a moment ago with Ms. Luo, in the past, you've seen the hospital with interns and doctors running around all over the place.
Yes, I have.
You've interacted with medical interns who are in a rush.
I have.
Let's see if one of those interns has a history of slipping up. The defendant herself actually specifically had a conversation with you about one of her interns.
Sorry, could you repeat the question? You cut out a bit in the middle for me.
My apologies, Miss Martin. We can agree that the defendant has had a conversation with you about one of her interns.
Yes.
An intern named Finley Riveras, right?
Yes, I did have a conversation on them.
As you told us a moment ago, the defendant told you this intern had made lots of slip-ups in the past.
That's correct.
And yet, ma'am, despite the defendant knowing about these slip-ups, you can't tell us that the defendant took any measures at all to make sure this intern didn't make a mistake again. Can you?
No, I don't know that.
Let's see if you can even tell us today whether or not the defendant mishandled the medicine. Truth is, you can't tell us about any actions this defendant could have taken to make sure that the hospital didn't mishandle the medicine.
No.
Now, a moment ago, you mentioned you wanted to have a career as a fortune cookie writer, correct?
That's correct, ma'am.
Well, ma'am, I have a fortune cookie right here. If I take it out of its packaging and you look at it, you can't tell me what the note says, can you?
No, I can't. But I do have to assume that it's something bad. These days, fortune cookies have been getting so terrible with their fortune predictions. Honestly, I feel like I could do better.
All right, ma'am, well, redirecting you back to my question, if you only look at the outside of this fortune cookie, you can't tell me what the note says, can you?
No, ma'am, I can't.
Similarly, you were only outside the hospital on the day Mr. Henley's life was cut short.
Yes, I was, ma'am.
And so you can't tell us whether or not the hospital mishandled the medicine, can you?
No, I can't, ma'am.
You can't tell us that the defendant took any measures at all to make sure that the drug was safe.
That's correct, but seeing how she's treated my daughter, I would trust that she did.
Ma'am, you just said that you trusted the defendant with your daughter. Truth is, you can't say this defendant was trustworthy to Mr. Henley today, can you?
No.
And you also can't tell us that this defendant didn't take shortcuts that day.
I can't tell you that.
Objection, Your Honor.
What is the basis for the objection, Ms. Love?
Your Honor, as to needlessly cumulative, at this point, Ms. Liu has already well established that Ms. Martin doesn't have knowledge as to the hospital protocols. It's improper for her to continue asking her questions, already knowing the answer is going to be no, because this witness is a late witness. She does not know this, and she has never said that she has.
Your Honor, may I be heard?
Yes, Ms. Love.
Your Honor, pursuant to Rule 403, it has to be substantially more cumulative than it is actually probative. In this case, Your Honor, the probative value goes towards what this witness cannot tell us. On direct examination, Ms. Luo asks a lot about what this witness knew in regards to hospital protocol, or rather, hospital operations, how the interns were treated, what the doctors were doing, and what the defendant did. In this case, Your Honor, I'm simply asking whether or not this witness understands and knows that the defendant didn't do XYZ steps. In this case, Your Honor, it certainly doesn't exceed that high bar. And Your Honor, I have a good faith belief that I'm almost done.
One more response, Your Honor.
Sure, Ms. Lowe.
At this point in the cross-examination, Ms. Liu has well established that Ms. Martin does not know anything about hospital policies. On direct examination, we didn't ask her about policies. We asked her about what she noticed. Your Honor, to keep having...
Yeah, but I gotta confess though, Ms. Liu, the first thing when I heard the objection and so on, I mean, the witness did testify as to what whether it be she observed or what she noticed. She had some very specific testimony about things, having brought her daughter to that hospital many times. So I don't think the questioning was overly cumulative or highly prejudicial. So the objection's overruled. That being said, Ms. Liu, why don't you wind it down as you suggested?
Yes, Your Honor, of course.
Yes.
Ms. Martin, I'll re-ask my question one more time. You can't say the defendant didn't take shortcuts on the day Mr. Henley's life was cut short.
I can't say.
Thank you, Ms. Martin. No further questions, Your Honor.
All right, Ms. Lowe, any redirect examination?
Yes, Your Honor.
Go ahead.
Ms. Martin, just a moment ago in cross-examination, Ms. Liu asked you a lot about the intern, who made slip-ups and who made mistakes. Well, ma'am, did the hospital fire the intern after she made all these mistakes?
No, they didn't.
Thank you, Ms. Martin. Nothing further.
Okay, any recross examination, Ms. Liu?
No, Your Honor. We'll let this witness get back to her daughter.
Okay, Ms. Martin, you are excused. Thank you very much. Does the defense have any other witnesses?
Yes, Your Honor. The defense calls Miss Elias Hornby to the stand.
Okay. Ms. May, please proceed.
Yes, Your Honor. Good evening, ma'am.
Good evening.
Could you please introduce yourself to the court?
Of course, I'm Elias Hornby.
What do you do for a living?
I'm an attending physician at Langford Hospital. I specialize in internal medicine. I also happen to be a full-time mother of a lovely boy, Jamie, and we live with my husband right here in Tilly.
How'd you get into your line of work as a physician?
So I actually started off studying molecular biology, but when my mom was diagnosed with lung cancer, I was able to see what a physician could, directly do for a family beyond just the microscopic concepts. And that's when I knew that I wanted to be the one to provide care as well.
Ma'am, I'd like to turn your attention to your professional background. Where'd you go to school?
I went to the University of Tilly to receive my bachelor's, and I got my medical degree from Tilly School of Medicine. I also completed my residency and fellowship over at the Little Hamlet General Clinic.
Can you tell us about your professional experience?
Of course. After getting my medical degree, I've worked at Langford Hospital since back in 2017, and I've been actively practicing for 13 years now.
Miss Hornby, have you been here for the entire trial today?
Yes, ma'am, I have.
Now, earlier today, the plaintiff said that you skipped safety checks and that cut short a patient's life. Is that true?
No, ma'am, that's not true. I've spent my life saving people. I never skip safety checks because that's the safety of my patients on the line, and that is no joke for a doctor.
Of course, Miss Hornby. I want to talk about what you know about this accident. Do you know what went wrong?
No, ma'am. To be honest, I have no idea. I remember the label on the syringe was accurate. It was lorazepam, not ketamine, not anything else, I was sure.
So, were you the one that filled that syringe?
No, it was my intern, Finley Riveras. She filled the syringe.
All right. Your Honor, at this time, let the record reflect we're going to be screen sharing a visual aid.
Okay.
Ma'am, did you have any concerns about your intern?
Yes, ma'am, I actually did. Rivera's had made mistakes before, once filling a syringe with the wrong drug. And I wanted to fire her, but my supervisor told me to give her another chance, so I did.
So, could you have fired her even if you wanted to?
No, ma'am, I don't get to fire her.
Why not?
Well, you see, I'm a physician, and I don't really have a say in who is hired or fired at the hospital. It's all decided by my supervisors and the hospital administration as well.
So, looking back at that syringe, was there any testing done after the intern filled it?
Yes, after everything happened, that I sent the syringe for a deep forensic analysis, and you don't know how shocked I was to learn that there were traces of ketamine residue.
Your Honor, let the record reflect that the defense is going to be screen sharing what's been pre-marked and entered as as Exhibit 3. That's a syringe recovered and sealed following Mr. Henley's death.
Okay.
Ma'am, looking on screen here, is this the syringe that was used in Mr. Henley's treatment?
Yes, ma'am, it is.
At this time, we invite the court's attention to Stipulation 16. The syringe depicted in Exhibit 3 was supposed to be filled from a bottle labeled as lorazepam. This bottle was tested by the Tilly State Police and found not to contain lorazepam. So, ma'am, was that syringe sealed before it was ever tested?
Oh, yes, ma'am. It was sealed and stored immediately after the incident. And to my knowledge, no one handled or opened it until the forensic testing happened.
Ma'am, let's take a closer look at this exhibit. Would you be able to smell anything through that plastic?
Smell? No, ma'am, of course not. I mean, syringes are tightly sealed for one purpose, sterility.
So even if you could smell that syringe, back in the hospital, would you have had any reason to believe that this syringe was filled with anything other than lorazepam?
No, ma'am. The label said lorazepam. I double checked and it looked like lorazepam too, and it was handed to me as lorazepam. There was just nothing to indicate otherwise.
Ma'am, I just want to make this clear for the court. Were you the one that filled the syringe?
No, ma'am, I was not the one who filled the syringe. It's not the physician's job to fill the syringe, it's the physician's duty to administer it.
And so, ma'am, looking back, what do you know about what happened?
It's scary how I did everything in my power to ensure my uncle's safety, but he still passed. I trusted our hospital to keep our patients safe. If only I didn't, my uncle would still be here with me today.
Thank you so much for your time today, ma'am. Your Honor, at this point, I have no further questions.
Okay, thank you, Ms. May. Ms. Garcia, cross-examination.
Yes, Your Honor. Ma'am, you've been here all of trial?
Yes, ma'am, I have.
You heard your attorneys argue that this case was about a hospital mislabeling the syringe of medicine.
That's right, and I believe that's what happened too.
Doctor, you're telling us under oath that you personally believe that label was incorrect on that syringe.
No, not at all. I saw it said lorazepam.
Exactly, ma'am, because you can't even tell us under oath today that you believe your own attorney's arguments.
Excuse me? I don't understand.
Ma'am, a moment ago you said you personally believe the labeling was correct, and that's exactly the opposite of what your attorneys have been arguing today. It's a yes or no question.
Well, that's a no to your question, ma'am. The label that Miss Luo, Miss May have been talking about, that's the label of a bottle. Because when you fill a syringe, you fill it from a bottle, and it was that bottle that was labeled incorrectly, not the syringe. So that's a no.
All right, ma'am, well, you're saying you don't agree. Let's talk about whether the choices you made constitute medical malpractice. Because at the end of your direct examination, you were saying that it was the intern's mistake for filling up the syringe, right?
That's right. Not just her, but also the hospital for letting her stay.
Pam, you're pointing the finger at other people, the intern, the hospital, but you were the one who chose for her to go get those drugs.
Well, not quite, ma'am. It's my responsibility as her proctor, or rather her doctor, in order to teach her what she has to do as an intern.
Exactly, ma'am. And you'd say when you teach, like in school, teachers don't let their students run unsupervised, right?
Well, of course. She was working under me.
But ma'am, that day, you didn't choose for her to write notes down during the treatment.
Objection, Your Honor?
What is the basis of the objection, Ms. May?
As to lack of foundation, at this point, Your Honor, there's been no foundation laid on the record that the intern or Miss Hornby wrote any sort of note.
Your Honor, may I be heard?
Sure, go ahead.
Your Honor, right now I'm exploring whether or not this defendant chose for this intern to do that specific job. And Ms. May's right. There wasn't any specific note taking. My exact implication of this line of questioning is this doctor chose for this incompetent intern to handle deadly drugs rather than simply wiping down equipment or choosing to have her write down notes during the treatment.
Yeah, I don't see any issue with it, Ms. May, the way this is going. It's cross-examination, so the objection's overruled.
Yes, Your Honor.
Yes, Your Honor. Now, ma'am, you could have chosen for this intern to write down notes during the treatment.
Right, but the interns are trained to take notes only when it's appropriate, not 24/7. So yes,
All
ma'am.
right, ma'am. Well, you could have chosen for her to wipe down the equipment for you during that session.
I could have, and Rivera's would have if it was what she was trained to do.
Ma'am, instead, you chose to give this intern another opportunity to slip up, didn't you?
No, ma'am. That is not true at all. It was the hospital
Yes.
that did.
Ma'am, you're saying it was the hospital who gave her an opportunity to slip up, but you personally ordered her to go into a room full of drugs and fill up a syringe.
That's right. I trusted her, I trusted the hospital's decision, and that trust turned out to be misplaced. But yes, ma'am.
Ma'am, you're telling us you trusted this intern. Let's talk about whether or not that would be reasonable for you to do so. Because, ma'am, this intern, well, she wasn't a licensed medical nurse.
No, she's an intern. She's still learning.
She wasn't a registered physician.
No, ma'am, that would be myself.
Ma'am, I see a lot of diplomas in your background. Well, ma'am, this intern, she didn't have any of those, did she?
No, she wouldn't have all of the ones that I have as a physician. You're right.
Exactly, ma'am, because this intern wasn't a medical credentialed nurse or physician.
That's right. She's an intern.
Exactly, ma'am, and you told us a moment ago you trusted this intern. Despite also telling your attorney, Miss May, a moment ago, she had filled up the wrong substances before.
That's right. That's why I wanted her fired. But the hospital had her stay, and it's my responsibility to let her do what she should be trained to do. So yes, ma'am.
All right, ma'am. Well, let's talk about what you allowed this careless intern to do, knowing she had messed up
Your
before.
Honor.
What is the basis for the objection, Ms. May?
Attorney testifying, we just asked Ms. Garcia not to testify when she's using her headers.
Yeah, I know. I understand that.
Well, I
Ms.
can
Garcia,
rephrase.
let's strike the word careless and, take the opinion out of the question. Go ahead.
Certainly. Let's talk about what you let this intern do, knowing she had messed up before. Because, man, you told her to go fetch that syringe, head into a room with deadly drugs.
That's not true, ma'am. She was supposed to fill it with lorazepam, and I didn't know at the time that she had filled it with the deadly drug, so no.
Ma'am, you didn't tell her to go into that room and fill up the syringe of drugs? Is that what you're telling us?
No, ma'am. What I'm telling you is what you just asked, that I didn't tell her to get a deadly drug. That's ridiculous.
No, ma'am, I'm not saying whether or not it was ridiculous. I'm saying you told her to get a syringe that was in a room of deadly drugs. That's what you told her to do.
Ma'am, I told her to get lorazepam, and there were other drugs in the room because it was a storage room for the hospital. Yes, ma'am.
Exactly, ma'am. And it's also a yes to my question. You didn't go with the intern and supervise her to make sure she got the right drug.
Of course not. I was preparing patient information, monitoring vitals, things I have to do as a physician, so no.
Ma'am, something else you have to do as a physician is make sure an intern isn't filling up syringes with the wrong medicine.
Absolutely, ma'am, you're right.
Ma'am, you showed us a moment ago a visual aid. I want to show that the members of the jury this visual aid and walk through whether or not it's true. Stating for the record, will now be screen sharing a visual aid. Because, ma'am, you told us a moment ago you couldn't smell the syringe.
That's right. You would not be able to smell the syringe.
You'd agree. If you were the one who was filling that syringe, you would have been able to smell the difference.
Objection, Your Honor?
No, ma'am.
What is the basis for the objection, Ms. May?
Your Honor, we don't believe that this is the visual aid that we showed Ms. Hornby today. We only showed Ms. Hornby the first point and the third point, without the third column of added instructions.
Well,
Your Honor, may I be heard?
yeah, sure.
Your Honor, we're going to be screen sharing exactly their version if Ms. May has an issue with that. But Your Honor, still the point stands that this was a visual aid they showed their own witness.
Okay, well, hold it. We could probably stipulate, going back to that document. That's fine. If you want to use this one, that's fine. Or you could stipulate that the third column is not part of the original exhibit. I don't personally care, as long as it's clear to the jury that the original exhibit only had these two columns. However you want to do it.
We're fine just showing the members of the jury this specific one.
Okay, that's fine.
Your Honor, if I may?
Yeah, yes.
We just like to make it clear for the members of the jury that we did not show Ms. Hornby the middle column where it specifically says to smell that syringe.
Okay, So let's back up. Ms. May, are you saying that this exhibit is not the same exact exhibit that you used?
That's right, Your Honor.
Okay, then let's make life easy, Ms. May. Put the exact same exhibit. Stop screen sharing, Ms. Garcia. Ms. May is going to put the exact exhibit that she used on the screen, and you'll use that one. Go ahead, Ms. May.
Yes,
Your Honor, just a point of order. This is a specific a visual aid. This was not entered into evidence at any point. It's not an exhibit.
You're correcting the judge, but that's correct, and that's not considered as an exhibit. But I want to see was that it? Or is that all that was shown was what we're seeing now, or there was another item? Ms. May.
What's on screen right now is all we showed to Ms. Hornby here.
Okay, then that
Your
being
Honor, may I be
said,
heard?
no, Ms. Garcia, you may not be heard. You initially represented that you were dealing with Ms. May's exhibit. I gave you the latitude and assumed it was, and in our business, we all know you never assume. Now we're not assuming. We are using Ms. May's exhibit. If you don't want to use Ms. May's exhibit, then this line of questioning ends and goes on to something else. Your choice.
Certainly, Your Honor. With that choice, we're not going to assume anymore. We're actually just going to stick with this exhibit.
Perfect. Please proceed, Ms. Garcia.
Yes, Your Honor. Now, ma'am, in this exhibit, you claim that you double-checked.
That's right, ma'am. I did.
Ma'am, we've heard from 3 witnesses today, and none of them have backed that up.
Well, that's right. None of them seem to be registered physicians. When we double check something, we look it over, and it's a fast process, but it's very thorough, ma'am.
Ma'am, you heard from Andy Parr today, someone who was in the room, and she said she didn't see you double-check that syringe.
I disagree. I did double check it. But
Ma'am,
I
I'm
did
not
hear
asking
her say
whether or
that.
not you double-checked it. I'm asking whether or not we heard you double-checked it, and we didn't. That's a yes.
That is a yes, ma'am.
And you also didn't verbally confirm with the intern she got the right drug.
No, I didn't, ma'am.
Co-counsel, we can take down the exhibit now. Now, ma'am, ultimately, after you claim that you double-checked, you administered that syringe of drugs to Mr. Henley.
That's right. I see you have a very nice picture of him right there.
Ma'am, after you claim you double-checked, you still injected the wrong drug into Mr. Henley.
Yes, ma'am.
And after Mr. Henley was under your care, and you trusted that intern, his life was cut short.
That's right. I shouldn't have trusted Rivera's. I shouldn't have trusted the hospital, but that's right, ma'am.
Your Honor, at this time, I have no further questions.
Okay, thank you, Ms. Garcia. Ms. May, any redirect examination?
Yes, Your Honor, if I may.
Please proceed.
Ms. Hornby, can you clarify what an intern is supposed to do?
All right. It's an intern's job to fill a syringe and do other basic procedures like that.
So, ma'am, turning your attention to our intern today, did you trust that intern?
No, ma'am, I can't stress enough that I didn't trust her, and which is why I became even more careful. I mean, especially after the hospital refused to fire her.
So why'd you let that intern stay?
Ma'am, at the hospital, as a physician, I don't make those staffing decisions. I raised my concerns. I did everything I could, but my supervisors decided to keep her on, and I can't do anything about that.
So, ma'am, did you double check that syringe?
Yes, ma'am, I did. I looked it over. There was nothing wrong with it that suggested to me there was a problem with what was inside the syringe, and that's why I injected my uncle with it.
Thank you, ma'am. Your Honor, I have no further questions. May Ms. Hornby be excused barring any recross?
Well, I wanted to give Ms. Garcia a chance for the recross, Ms. May. Any recross examination, Ms. Garcia?
Yes, Your Honor.
Okay, go ahead.
Ma'am, you just told, yes, Your Honor. Ma'am, you just told Miss May that at that time, when you were giving Mr. Henley those injections, you didn't trust the intern.
That's right. I never trusted Rivera's, which is why I got even more vigilant with double-checking content of the drugs.
Ma'am, I just want to confirm that's your sworn testimony today. At that time, you didn't trust the intern.
That's right. Even
Ma'am,
though
you're
the
aware that you
hospital
made
had
a-
let him stay.
My apologies, ma'am. I think there was an error on my end. Continue.
Right, ma'am. I was just saying how even after my supervisor had her stay, I still became even more careful because of the mistakes that Rivera's had made. So that's a yes to your question.
Ma'am, you're aware that you made an affidavit before coming to court, correct?
That's right.
Stating for the record will not be screen sharing Dr. Elias Hornby's affidavit for impeachment purposes. Ma'am, this is your affidavit. It says Dr. Elias Hornby.
I think it said so. It just disappeared.
Right there, it says it on the bottom, correct?
I see here it says at the top.
Ma'am, if we scroll down to the bottom, it also says Dr. Elias Hornby.
Yes, ma'am. That is my signature.
Co-counsel, directing your attention to page 26, lines 34. Ma'am, I'm going to read silently, or rather, I'm going to read aloud while you read silently.
All right.
Your Honor, I believe the crossing has reached time limit.
Oh,
Your
well,
Honor, may I be heard?
there's not much to be heard, Ms. Garcia, but you can ask me what you'd like, but at this point, you're out of time.
Your Honor, that's not my understanding.
Hold it. First of all, let's back up a step. How many timekeepers do I have?
There are two, Your Honor.
Okay, do the timekeepers agree that Ms. Garcia is out of time?
I
No,
believe
Your
she is, Your Honor.
One says she is and one says she isn't? I'm trying to give everybody a chance here. What is the dispute between the timekeepers, so I understand?
I believe Miss Christiana Garcia still has 15 seconds left, and there's also a 30-second grace period as well.
Okay. And does the other timekeeper disagree with any part of that?
She's 10 seconds over time from my count. If she has 20 seconds of the grace period, if she has a 30-second grace period.
Oh, well, okay. Are you not aware of a grace period rule on the time of the timekeeper? Okay. That being said, okay, Ms. Garcia, you have both timekeepers adjust your clocks. You have 20 seconds to finish what you're about to deal with, Ms. Garcia, giving you the benefit of the doubt here. Okay?
I appreciate it, Your Honor.
Go ahead.
Now, ma'am, if we scroll down to line 142, it specifically states that at the time I trusted my intern. I read that correctly.
That's right. It was at the time.
Your Honor, at this time, I have no further questions.
Thank you very much. Dr. Hornby, you are excused. All right, are we prepared to proceed with closing arguments?
Yes, Your Honor, but before that, the defense rests.
Okay, yes, I apologize, Ms. May. So there are no other witnesses for you?
No, Your Honor.
Okay. That being now said, are we all prepared to proceed to closing arguments?
Your Honor, if possible, we'd ask for a small break.
Okay, do you have any objection to that, Ms. May?
We have no objections, Your Honor. We're fine with the small break.
Okay, then that's what we'll do. It is now on my clock 9 minutes after the hour. We will pick up again at 14 minutes after the hour, okay?
Yes, Your Honor.
Thank you. Okay, everybody should be back. And with that, let us hear the plaintiff's closing argument.
Yes,
Please
Your
proceed. Please proceed, Ms. Liu.
The defendant's shortcut cut a life short. Members of the jury, let's take a step back and talk about the very beginning of today's trial. Today, when Ms. Garcia and I stepped into this courtroom, we introduced our intern, Crystal Day. Now today, you didn't see Crystal perform any material, let alone do it unsupervised. Because if Ms. Garcia and I told her to do that, if we told Crystal to step into a serious trial with no expertise and no qualifications, that would be malpractice. And if she made a mistake, we would be responsible for that mistake because we took a shortcut. Members of the jury, lawyers shouldn't take shortcuts in courtrooms. The same goes for hospitals. But today you learned that this defendant allowed her unqualified intern to handle a life or death situation because the defendant took a shortcut. And now the defense keeps telling you that the hospital mishandled the medicine. And they're halfway there. The hospital could have mishandled that medicine, but today, that's not what this case is about. We already know that drug was wrong, but in this case, it's about why that wrong drug cut a life short. That mishandling only cut Mr. Henley's life short because the defendant decided not to check the vial, not to fill the syringe. Instead, she handed her job to an intern who she knew had slipped up in the past and didn't think twice about it. That's why today, on behalf of Mr. Henley's estate, we're suing the defendant for medical malpractice and wrongful death. That means we've taken on a burden. That means if you find it more likely than not that the defendant's shortcut cut Mr. Henley's life short, then the defendant is liable. And today we've done that through two facts: the slip-up and the shortcut. First, the slip-up. Today, we had a slip-up in court. During a direct examination, the defendant said she trusted the intern, while on redirect, in another breath, she said she wouldn't trust that intern at all. You saw the exact opposite of what she was saying outside of court, because this defendant can't get her story straight. She's grasping at straws because she knows trusting that intern was an error on her end. That's medical malpractice. Now today, there were 4 witnesses who took the stand and testified. All of those witnesses told you they agreed on one thing. It was that the intern had slipped up beforehand. And as you heard from the lawyer who liked to predict the future, well, she can tell you that in the past, the defendant has always known that this intern was unqualified. And yet, on the day Mr. Henley's life was cut short, the defendant could have told this intern to get coffee, wipe down equipment, or take notes, like what Ms. Jiang has been doing. But instead, the defendant handed a syringe like this to her intern, made her intern step into a facility with deadly drugs. That's the defendant's shortcut. Members of the jury, that's why we brought forth a claim of medical malpractice against this defendant. The defendant owed Mr. Henley proper care, and as you heard today, from an expert in drug analysis, the defendant breached that standard of care. The defendant breached that standard because she didn't check, didn't verify. Members of the jury, you heard today, the only person who can corroborate her story is herself. Is herself the defendant who perjured herself on this stand. Because she took a shortcut, Mr. Henley died. That's why we've brought forth a claim of wrongful death against this defendant. We can both agree that Mr. Henley died because of the wrong drug. And today you learned because the defendant never checked to make sure the drug was right, Mr. Henley died. His death is a loss. His family and his estate were directly harmed. Mr. Henley's life was cut short because of the defendant's shortcut. That's why we'll ask you to find the defendant liable. Thank you.
Okay, thank you, Ms. Liu. Okay, the defense of a closing.
Yes, Your Honor.
Okay, please proceed, Ms. Love.
The hospital mishandled the medicine. Members of the jury, for just a moment, let's take a break from discussing syringes and doctors and talk about something a little bit easier to understand. A school. Because there's a student and she's about to take a test. Now, this student studied hard, she was prepared, but when she walks into that exam room, everything goes wrong. Her pencils break, the teacher hands her the wrong test, and the student fails the exam. Things that were out of her control messed everything up. And that's exactly what happened today. Because the doctor had the training. In fact, Dr. Hornby has properly treated the patient several times before, and she followed all the standard procedure. But things went wrong because the hospital forced her to keep an untrustworthy intern and mislabeled medicine. Now, the plaintiff tried to argue today that her shortcuts cut a life short. But members of the jury, you learned countless times today the hospital's shortcuts cut that life short when they mishandled the medicine. And that's why we're here in court today. Because the plaintiff has something to prove against Dr. Hornby. They have a burden of more likely than not, my client committed both medical malpractice and wrongful death. And really, what that means is if this case comes to a 50-50 split and you don't know what to choose, well, members of the jury, that means you got to choose not liable. And they failed. The plaintiff failed to meet their burden today because of the same three facts. Medicine, malpractice. Let's go through that. Before that, Your Honor, I apologize. I believe that there's something going on outside of my room. If I could briefly go handle that.
Sure.
Sorry, Your Honor, there's an interruption. So sorry about that. That was my younger sister.
Okay, keep on going, no problem.
Okay. So let's talk about those three facts. First, the mislabeled medicine. Because members of the jury, you learned today from the plaintiff's own expert witness on cross-examination that the hospital had mislabeled medicine. They had a bottle of ketamine with the wrong label of lorazepam stuck on it. Members of the jury, I don't need to tell you how dangerous that is. It is the equivalent of mislabeling rat poison as dog food. Because the hospital mislabeled the medicine, a patient died. But second, the mistake the intern made. Because members of the jury, every single witness who testified today had something bad to say about the intern, and for good reason too. Because the intern that assisted Dr. Hornby and filled the syringe was completely incompetent. They misfilled syringes in the past, forgot to sanitize it properly. They made mistakes that should have gotten her fired. And Dr. Hornby wanted to fire her. But the hospital just wouldn't let her because the intern had too many connections. Now, just a few minutes ago, Miss Liu tried to connect a law intern to a hospital intern. But members of the jury, there's not much on the line for filling up paperwork. There's a law on the line when a hospital allows an intern who keeps making mistakes to keep her job just because her parents work there. There were lives on the line that the hospital ignored. So finally, let's talk about how the hospital mishandled the whole situation. Because you learned today from the lawyer who constantly visits the hospital about how understaffed it is. How doctors are stretched thin, constantly stressed out. You even learned how syringes are filled with the wrong substance. That's not a doctor who takes shortcuts. It's the hospital. Because the hospital mishandled the medicine. And the plaintiff today tried to bring up 2 points. Let's go through them. First, Miss Liu talked about slip-ups. And we just want to make the slip-up clear. Because in general, Dr. Hornby did not trust the intern. She didn't trust an intern who kept making mistakes. What she said was true. But it's also true that she did trust the intern to do a simple job. A simple job of filling the syringe, not injecting medicine into patient. Dr. Hornby trusted her to do something easy. Second, Miss Liu talked about the shortcuts, how trusting the intern was a shortcut that broke protocol. But members of the jury, you learned today under oath that Dr. Hornby told you it isn't the doctor's job to fill up the syringe. It's the doctor's job to administer treatment. And not only that, Dr. Hornby certainly did double check the syringe. She looked at the label on the syringe, she observed the contents, it looked right. She followed all the necessary protocols, but she did not have any control over the hospital keeping mislabeled medicine or refusing to fire an intern who made mistakes. That's the hospital's responsibility. Now, earlier in today's trial, we pointed out a case law, Minerva v. Rickman, which states that doctors don't have to guarantee a successful outcome for a patient, and an error is certainly not automatically considered a breach in care. Members of the jury, no matter how much the plaintiff tries to blame my client, the truth is it's just not her fault. She didn't take shortcuts because she did absolutely everything she could do. Dr. Hornby had no control over the mislabeled medicine. Dr. Hornby had no control over the intern's mistake, and she certainly didn't have control. The people who did have control was the hospital. And they made the mistakes when they mishandled the medicine.
Okay, Ms. Lowe, you're out of time. Okay, thank you very much. Okay, Ms. Liu, do you have rebuttal?
Yes, Your Honor. Before that, could I request a time check from one of the timekeepers?
I believe you have 1 minute and 20 seconds.
This sounds fantastic, Your Honor. May
Go
I
ahead.
proceed? Ms. Luo just told you about a student, and she's right. But in school, a teacher doesn't leave her students by themselves to take a test. The defense keeps telling you that the hospital should have fired the intern, but members of the jury, today you learned this defendant chose to leave this untrustworthy, unqualified intern, throw her into a life or death situation, and just hope for the best. She didn't have to, but she did. The defendant chose to let her intern do her job for her. That's the shortcut. And today you learned that because of this shortcut, because the defendant didn't do the job she was supposed to do, she breached a standard of care. That standard of care cut Mr. Henley's life short. And that's why now we'll ask you to find her liable. Because the defendant's shortcut cut a life short. I appreciate your time today.
Okay, thank you, Ms. Liu. If everybody could please turn your cameras on, just so the judges can see who everybody is in filling out the scoring papers. All right, just give us a few moments to fill them out.
Fantastic round of mock trial. Very excited indeed to hear some of the comments from our esteemed judging panel. Let's start with Miss Ellen Song.
Hi, I'm sorry, I couldn't turn my video on because it's still disabled.
Oh, let me enable that.
Yep. Hi guys, that was really an amazing round. I just have, I guess, like one point that I wanted to make, because at your level, I feel like there's more like to consider about strategy rather than the content of, say, like objections. So I thought it would be better actually to have some strategic patience. For example, during like crosses, sorry, my cat is kind of, okay, sorry. I thought it was better to kind of have more patience when the opposing side is kind of making a sort of a confusing point on cross, because if you object to relevance, it actually gives them a chance to kind of strengthen or like reframe their argument to the jury. So that I guess is like a tiny point that I would say, but overall just really polished and extremely good.
Thank you very much. Let's go to Jessica.
All right. Hi, everyone. That was an amazing round. very, very high level of competition. I was so impressed by so many of you, from your expressions to the power in your voice to your especially the attorney's knowledge on objections. I find that very impressive myself when you can just pull something out of your hat. It was very clear to me that a lot of times when you were constructing your arguments, you thought of every single possible objection that could be raised. And so you had a polished response to that, or you've practiced it so much that it sounds like it was a polished response. And that was just really cool and really impressive to me. Yeah, I loved it so much. And our witnesses, I am a former theater person myself. I dabble in it from now and again, every once in a while. And I really appreciate costumes, things in the background, props, funny references. And I also appreciate when the attorneys themselves catch on to that and you make a reference to it, or you say it in your parting greetings. Oh, I'll let you get back to your daughter or your theater or your cat or whatever have you. Yeah, many moments like that. I really appreciate the nerd in me. I have a few more detailed responses to specific things in my comments, specifically when it comes to like medical stuff that is part of my interests as well. And you guys can take a look at those. But really, really impressed with all of you. You should all be proud of what you did today. And I can't wait to see what you all come up with in the next case. Good job.
Let's go to Nora.
Great job, everyone. This is a really high level round and I enjoy it a lot. I will make a comment on redirects and recrosses. I feel like a lot of the time, if this redirect doesn't save your case entirely, it's a little bit unnecessary because you will never get dock-off points for not having a redirect, but sometimes you get dock-off points for having one. So if it doesn't save your case, I would kind of suggest against having a redirect, or you should really consider like when do you want to redirect and when do you want to recross. That being said, great job, guys. I enjoyed this round a lot.
And of course, to our presider, Stephen Noodleman.
Yeah, I thought it wasn't. I agree with all the other judges. I thought it was a very, very good, well done round. And you should definitely be proud of yourselves. The two, I guess, I don't call highlights or big points that jumped out at me. I thought that was a very high level, good argument about the will. I thought that was very well raised about Rule 703. I also thought that, yes, it's still the witness, it's the testator, it's the guy who's writing the will. They're really his statements. So, I mean, that was brought out very nicely. I mean, that's a very sophisticated point that was raised. I thought that was very, very good. I thought the witness, as an aside, Mr. Bay, I thought was or Bai, I apologize, was very good. I mean, I thought that he was really kept good control over much of what went on with him, and I thought he kept it all together pretty nicely, and I like that. The other point that is, I thought that Ms. Garcia did a terrific job going after Dr. Hornby, focusing on the lack of superintendency over the intern. My comment says it. I said maybe you should have quit while you were ahead, because at that point, then you got into this business with the exhibit, I didn't mean to be too realistic as a judge, but I could be in front of a judge like that and they'd get a little bent out of shape and ruffled, because here they were, giving you the benefit of the doubt, assuming that what you were showing was exactly the exhibit. And I didn't have, normally a law clerk would probably hand it over to me and say, look at what's going on. So you want to be careful about that, because something like that, could, especially at a very, very high level like this, could change a little bit of how things are going. But right up to that point, you were dismantling Dr. Hornby. I thought that was very nicely done that whole way. And I was, thought that was very impressive. And I agree. Usually when you see these things as a judge, a mock trial judge, you don't see enough redirect examinations whereby somebody should be using it if you're going to rehabilitate your witness. If your witness has been damaged, on cross-examination. You want to use the redirect to rehabilitate them. And most witnesses remain damaged because people don't bother to do the redirect examination. Here, because you're dealing, I think, with very high-level teams who are picking up on every word that's being said by everybody, you had a little bit more of that. So I don't necessarily look at that as a bad thing. I don't think anybody really got carried away. I thought that was actually very impressive. That's one thing that both teams seem to have done very well, which is picked up on what the other side was saying. Because I always tell people from where I sit, same with a trial as well as a mock trial, it's very, very important to hang on every word. You know, that way you don't miss objections, that way you don't miss things for lack of foundation and other things along those lines. And as I said, for the other trials I had judged, the one thing that troubles me about this problem, and I'm not usually smart enough to pick up on troubles and problems. This one, I thought it was fascinating that the plaintiff is using a pharmacologist expert to prove a medical malpractice case against a medical doctor, as opposed to a medical expert. And no one, I've not seen a trial where it's come up, where anyone's raised that and said, well, this doctor is not competent to opine about whether the medical doctor fell below the standard of care as a medical doctor. You know, so who knows? Maybe the problem writers will tweak it for the December thing and stick in some medical background on the part of the pharmacology guy. So that way, you know, somebody has that added twist that he has a basis to opine that. Because I was once in a case where the issue was a foot doctor and a problem with a foot doctor. And the plaintiff called a podiatrist as the expert, and the defendant called an orthopedist that specializes in feet. They are very different people. They have very different sets of expertise. And the guy that, in the end, it actually made a difference because the defendant was successful and had a much better expert. You know, and the jury was much more taken by an orthopedist who specializes in feet than a podiatrist. So just an interesting point from where I sit as an outsider. But again, I thought that you guys did a terrific job. It was very enjoyable to watch. And congratulations to everybody.
Congratulations indeed. There's a quotation from the TV show Succession that I thought summarizes this round very well. The last time that this team faced directly was the semifinal contest. This was some time ago. It was about 9-10 months ago. And when this team faced an elimination round, it was incredibly close. It was a 3-2-1 decision that was decided by 1 point on one ballot. Then this team faced again in the preliminary round, and they split. One side was +3, the other side was +5. Once again, we have a quite contentious round. The quotation that summarizes it is, "Life's not knights on horseback. It's a number on a piece of paper. It's a fight for a knife in the mud." And that's the level of intensity that I found in this very good round of mock trial. So, predictably, we have a split decision for the MVPs. Co-MVPs for attorneys with 2 votes apiece, Miss Christiana Garcia and Miss Anya. There was a 3-1 decision in favor of one witness in this trial. Your MVP witness is Miss Lily Kizirian. That takes us to the scores. All 4 ballots were decided by single digits, but it was a clean sweep round. On a 4-0 decision, the champions are the plaintiff, the Monkey King, Sun Wukong. Congratulations both to the champions and to our runners-up, Team Beowulf. We'll see you next contest.